Speaker is Dr. Shivkumar Kumbar F., a name synonymous with medico-legal expertise and academic versatility. We welcome Dr. Shivkumar Kumbar sir to share his expertise on legal aspects we must all be mindful in our daily anesthesia practice.
It's with great respect and joy that I introduce Dr. Shivakumar. As has been stated, he is a medico-legal luminary, and recently our profession as such is facing a lot of medico-legal issues, and we actually need to learn how to deal with law and how it matters to us and our patients. Dr. Shivakumar has about 10 degrees after his name, and he's still continuing on the path of eternal learning. Sir did his MBBS from Gulbarga Medical College and DA from Karnataka Institute of Medical Science, Hubli. And then he has a lot of legal degrees to his name. Currently, his most important role is as a medico-legal advisory for any anesthesiologist in need of help, as well as he's a member of the mediation cell of the Dharwad District Consumer Court. He has also written prolifically on all these topics. Beyond all that, our interaction of the past 4 months, he is a personality that I've come to immensely respect, and because he embodies whatever Dr. Vasant just said, which we will probably hear in his talk. Thank you.
Thank you, sir. Thank you very much, organizers, for giving me an opportunity to share a few of my medical legal experience, especially for the anesthesiologist. For the last 3-4 days, you have been bombarded with the academics. Now, I would like to take you a bit away from the academics. And I would say that's legal academics. Don't get scared for any other things. Yeah. The topic what I have chosen today is navigating legal threats from pre-anesthetic examination room to the courtroom and sometimes beyond that. So what exactly is the negligence? When you decide to anesthetize a particular patient, you have a contractual relation with the patient starts. This is very, very important. Tomorrow you are being posted on case. You are gone today for the PAE. Morning you are posted in emergency, you talk to the patient, start IV, check with the IV line, your obligation to the patient starts. So for obligation to start place, we have 3 important things. Duty of care. This begins once the anesthesiologist accepts the responsibility to provide anesthesia care. Then, if there is a breach in that duty, there is a negligence. And because of that duty and breach of that duty, some harm caused is a negligence. And there has to be a direct link between the anesthesiologist action or inaction and the harm. These are the 4 fundamental elements of negligence, what you routinely cause. Kannada many times ನಾವು ಹೇಳ್ತೇವೆ ಮಾಡಬೇಕಾದದನ್ನು ಮಾಡದೇ ಇರುವುದು ಮಾಡಬಾರದನ್ನು ಮಾಡುವುದು. This is called as medical negligence in Kannada. So what are the root causes for anesthesiologists to get entangled into the legal complexity of the nature of the anesthesia work? Maybe you have posted 6 or 7 cases, probably the outcome may be poor if at all you are very much stressed or fatigued. Then I come across a lot of consent-related issues, lack of communication to the patients, patient relatives, or to a certain extent to the surgeon also, and human-related errors due to the medications. So what is the risk assessment for the anesthesiologist? Healthy patient by 12% mortality, the mild systemic disease, no functional limitation, 0.7 mortality, severe systemic disease, a definite functional limitation where there is a 3.5%, and also severe systemic disease where the constant threat to life is 18.3%, and moribund patient unlikely to survive 24 hours with or without surgery is a 93.3%. Why I am going to tell this is important. So many times the surgeon do tell us, sir, we have taken a high-risk consent, physician advice, cardiologist has given a consent, fitness, he go ahead at it. What exactly the high-risk consent means? High risk could be if the individual risk of mortality is more than 5%, or if the mortality is more than 20%, which you can call it as extremely high risk consent. And many times there is tendency for the surgeon fraternity to take, sir, however it is said, we have given a consent for the grave risk consent. Friends, you believe me, there is nothing like a grave risk consent. It does not stand 1 or 2 minutes in the judicial scrutiny. Do not even entertain the grave risk consent. Many times you do come across, you are reluctant to give anesthesia, but the surgeon says that, sir, the patient has given a death on the table consent. Can you expect anybody to give a death to die on the table? I don't think it's humanly impossible. Rather, you wish to die in room or in the ICU rather than risking yourself that he's going to die on the table. So nobody gives a consent for death on the table. However, it is worst. It is against the Indian contract law as well as the public law. Please do not take a consent for the grave risk consent or on-table death consent. It doesn't stand the scrutiny in the judiciary. Many times, 10, 15 years back, whatever the mistakes were being done by anesthesiologists and clinicians, they were never ever considered the negligence of anesthesia. Always the respondent superior, the captain of the ship is the surgeon. So most of the responsibility was shifted onto them, even though there was some negligence on the part of the anesthesiologist. But this landmark judgment, Mumbai Grahaka Panchayat versus Dr. Fadnis, the patient died immediately after the operation. The state consumer held that surgeon negligent, anesthetist can't be negligent even if it is proved that anesthetist acted negligently. But they appealed to the National Consumer Forum. The Consumer Forum categorically said that the services of the anesthetist are paid by the patient, or else by the hospital, or else by the surgeon. The anesthetist was therefore as much liable as the surgeon if the negligence is established in the court of law. So that you cannot escape from the liability if the negligence is proved by us. Next what? Many times, the public or the relatives knock the door of the justice. In what capacity? Yes, they can go to the civil court, very rarely. But most of the times, what I have come across for the last 10, 15 years, 92% of the patients or relatives knock the door of the Consumer Protection Act, which is amended in 2019. And recently, we used to say that IPC or CRPC, now it is changed from July 1st, 2024, is called as BNS, Bharatiya Nyaya Sanhita, instead of IPC. Many times, they do knock the door of the councils, like State Medical Council, MMC, whatever it is, and there is a recommendation action where the State and the National Human Rights Commission also, they have been informed about the negligence of the doctors. Especially the PAE, pre-anesthetic examination, is very, very important because it's a crucial step before surgery and it's illegal and protects the healthcare professionals from litigation. Courts consider PAE as an essential standard of care. PAE is a mandatory in all major or supra-major surgeries and the patients who are suffering from the comorbid conditions. There are many instances wherein the opponent advocates ask only one thing: did you ever done a PAE? If you say no, the court thinks that when the 90% or the more than 50% of the people, they do a PAE, if you are not doing PAE, probably it is a deficiency on the part of the anesthesiologist having accepted the case. So PAE is a very, very crucial thing. Never ever forget it. Sometimes, even if you forget, don't forget to mention the case paper that you have done a PAE. In Arunabhen Katari versus Navdeep Clinic, very, very interesting case, which I always case when you come across the PAE or the physician fitness. A middle-aged man was supposed to undergo a forearm surgery. Anesthetist was reluctant to give anesthesia because ECG was showing STT changes. BP was 140/100. The cardiologist got in, he said that ECG is showing non-specific changes, even though it's infralateral or anterolateral. Intraoperatively, patient had a cardiac arrest. When the cardiac arrest occurred, a cardiologist came, he said that patient had a cardiac arrest, and he certified the death. The court asked only one thing for the anesthetist: why did you rely on the fitness of the cardiologist? Then also relied, how come the cardiologist can give a cause of death in the OT? The anesthetist said that, no sir, surgeon urged me to give anesthesia because cardiologist has given a, you being an independent specialized person. Why did you rely upon that? That was the contradictory statement. Never ever believe unless you interpret yourself that whether the patient can withstand the risk of surgery. Otherwise, the physical fitness has no value at all. So in this case, 4,15,000 awarded, wherein the anesthetist has to cough out 60%, surgeon 30%, and the cardiologist 10%. One more very interesting, Parel Hospital versus Uma Mangesh, Dr. Ajay, a 66 years Parel Hospital, a fracture of forearm. Patient was not fit for the general anesthesia, anything. So the block was failed. The ketamine was given, patient slipped into the coma, he intubated, and patient was put on a ventilator. Ultimately, MRI said that hypoxic encephalopathy in the patient. And he died after 4 months. District Forum did not entertain this. It was rejected. Then the State Commission held negligence of anesthetist, orthopedist in the hospital and awarded 12 lakh compensation. National Commission, they appealed to that. Again, they said that PAE was not done properly by the anesthesiologist. The drugs what you use, ketamine 14 compounds, is exists. What the routine anesthesiologist would not have used it. So they landed up in a hypoxic encephalopathy, for which all three of them were held responsible. Many times you do come across intraoperative crisis. A 65-day child, a hernia was to be posted by the pediatric surgeon. Intraoperatively, there was hypothermia, for which a water bottle, warm water bottle was wrapped, and there was a severe burn under the tree soon after the surgery, and anesthetist was held liable because Doctrine Prescription Locator says that the thing itself speaks about that. You don't have to prove it in the court of law. So the surgeon, anesthetist, and hospital was jointly and severely responsible. Many times in this monitoring era, we put the patient on monitors and we go out for a cup of tea or coffee. Ultimately, we land up in such of the problems. This is a very interesting case. Parishit Lal versus Santosh Hospital in 2023, National Consumer Forum. A death of a pregnant woman and unborn child. Held Bangalore-based hospital anesthetist guilty of negligence and ordered to pay 1.6 crore compensation. Probably this is what I have come across, excess compensation. What happened was, the lady, pregnant lady who was supposed to undergo the cesarean, she had a spinal deformity. The anesthetist was supposed to induce it to the general anesthesia. The patient became unconscious, and anesthetist, joining hands with the obstetrician, said that I gave a pentothal because spinal was not possible. So after giving pentothal sodium, the patient had anaphylaxis reaction. We did our best. Ultimately, patient died. But when they subjected to the postmortem, they found that there was hemoperitoneum, fracture of the sacroiliac joint. And the question arises, how could a pentothal can give, or anaphylaxis can cause hemoperitoneum, which is never ever heard in the literature? How can it cause a fracture of the iliosacral joint? It proved beyond doubt in the court of law. Yes, the patient fell in the OT, either on the OT table or before entering the surgery. That was the cause for that, wherein anesthetist tried his best to fabricate all the documents. All three of them were held responsible. Never ever do that. And this is very, very treat, but don't tweet. In Texas, USA, distracted doctoring, a 60 years old woman, low risk cardiac patient, and posture was going on. There was a sudden drop in the SpO2 for which anesthetist was not noticing it because it proved beyond doubt he was chatting with the social media or he was using his iPod, and even also, surgeon also endorsed it. Ultimately, it proved that anesthetist was held responsible because he concentrated on the mobile gadgets rather than concentrating on the patient's monitoring. Many times we do come across to please the surgeons, whatever it says. We ask, surgeons said that intraoperative give 1 gram of ceftriaxone, 2 grams of ceftriaxone. Never ever do it. Never ever do it. I have come across 4 or 5 cases where the anesthesia lauded in problem. There was anaphylaxis reaction to the antibiotic, but ultimately the owner fell on the anesthesia stating that it was because of the anesthesia. In this case, Ram Kumar versus Tagore Medical College and Hospital, anaphylaxis shock and hypoxic encephalopathy, wherein the patient went into the vegetative because the anaphylaxis shock was not very well managed, the testosterone was not given, and this, they awarded 51 lakhs, and also since the patient became vegetative, 75,000 per month on monitor grounds and nursing care throughout the patient's life. Never ever do intraoperative antibiotic unless the patient was already given. You instruct them to give the antibiotic half an hour before the induction of anesthesia, then we'll come to know that whether we can withstand the anaphylaxis or not. So medication errors commonly we do come across look alike, sound alike. Tranexamic acid and local anesthetics, digoxin, lidocaine, epinephrine, ephedrine, ondansetron, phenylephrine, acetaminophen, acetazolamide, hydralazine, hydroxyzine, amantadine, amiodarone. These are few of the drugs. Never ever do this kind of a medication error. I have 2 cases last month only from Karnataka. This is a very interesting case. Dr. Sutappa Dasgupta versus Takankar, wherein the electric seizure was to be done. Spinal anesthesia as usual is given. Patient developed paraplegia. District and state commission held that anesthesia was negligent. MRI spine showed that there was a hemorrhage collection and edema anterior to the spinal cord from T12 to L4. Surgical decompression on the 4th day. But it held that surgical decompression was done on 4th and 5th day. Rather than that, probably it would have been on 2nd or 3rd day, for which anesthesia was held negligent. Delegation of the crucial duty to the trainee junior doctor may amount to breach of duty on the part of the senior doctor. In this very interesting case, a faulty intubation was done by the junior anesthesiologist, which was not properly supervised by the senior anesthetist, for which the court slapped 10 lakhs compensation in Manipal Hospital on the part of the anesthesiologist. See, failure to intubate is not a negligence. Okay, inappropriately, with a great difficulty, even if you intubate esophagus, okay, that time failure to detect is fault of the anesthesiologist. Anaphylaxis reaction is not a fault of anesthesiologist. Failure to manage it, recognize it in due time is a negligence. So many times you do come across daycare surgeries. In this PMC, baby dies after the MRI in Kamala Nehru Hospital, Maharashtra, who was mentally retarded, and anesthetist induced the baby and baby died. PM was conducted, held that anesthetist was negligent because he did not have a proper infrastructure to revive the patient if something goes wrong. Even Mohammed Sheikh Ganesh Chandra, 2016, a MRI brain was to be done for the patient who was suffering from the CA breast to develop the secondaries, and 2 doses of sedation was given. Patient died while doing the MRI. By the time the patient was taken out from the tray, was trying to intubate, patient already, they lost it. This is Umadevi versus Yeshwad Hospital, very interesting case. ARCP, very simple procedure. They were doing it, propofol is given by the anesthesiologist. Soon after the procedure got over, patient slipped into the vegetative state or brainstem, and after patient died in the vegetative state after 2 years, a state commission held that there was a negligence on the part of the anesthetist and awarded the 10 lakh. Ultimately, they went to the appeal, which they could not entertain it, and again, it went to the 47 lakhs. Many times, it happens so, we have managed a case, because of this somewhere, you need to shift the patient to the tertiary care center, higher center. How exactly you need to shift him, very important. In this case, Sheikh Ahmed Wakil versus Miss Parin Irani, 1999. A cesarean was taking place, Pasig General Hospital, I believe. Intraoperatively, gynecologist warned anesthetist that the blood is a bit dark. I took it lightly, and there was a cardiac arrest. He intubated, and he did his best to revive the patient. Ultimately, the patient was fighting with the endotracheal tube, and he removed it, and it was decided to shift the patient to the Bridge Hospital. And anesthetist, to our surprise, everybody's surprise, he said that ambulance can be taken away to the Bridge Hospital, wherein I will accompany the patient in my car. By the time the patient reached Bridge Hospital, they said that the patient had already hypoxic encephalopathy, for which they awarded 4,10,000 rupees on the part of the anesthesiologist. It is a duty on the part of the anesthesiologist. Morally, ethically, he would not have left the patient without accompanying him to the ambulance. And whenever you interfere, make sure that you accompany the patient, or else it may not be possible, but a skilled person who is trained in the CPR should accompany the patient till the patient reaches the tertiary care center. Impact of the anesthesia 2019, probably I would say that hanging sword on the anesthesiologist, how draconian for all of us. Friends, the pecuniary jurisdiction is 50 lakhs to the district consumer, 2 crores to the state consumer, more than 2 crores is the national consumer. What exactly is meant by that? A patient can file a case against an anesthesiologist wherever he works, wherever he resides. Two important things. If the patient has undergone a surgery in Mangaluru, if the patient resides in Jammu and Kashmir, they can issue a notice for you from there only, for which you have to go to that place and represent your case to the lawyer. If you have 4 cases in a year, that's enough. You don't have to attend the conferences. That should be enough. And no capping for the compensation being asked. What I told you, 50 lakhs, 2 crores, more than 2 crores, it is the amount of consideration of what you have paid to the hospital. For example, the hospital bill is 20,000 rupees, which comes within the 50 lakhs. The case has to be filed in the district consumer, but the compensation may be in terms of the crores. There is a difference. Irrespective of the hospital bill, the patient can ask for the compensation in multiples of crores. There is no control over that. And imagine that you have won the case, you have been proved in the district forum of the Mangaluru court that there was negligence on the part of the anesthesist, and you said that there is no negligence. You want to appeal to the higher court. So appeal to the higher court, you have to deposit 50% of the compensated amount in the higher court, then you can go to the appeal. If there is a 50 lakhs awarded to you, and you are very much sure that with the help of the Dr. Kumar, and you want to fight that case, you have to deposit 50% of the awarded amount, then you go for the appeal. You are under dilemma, whether to pay and get rid of it, or else you have to go and appeal for that. Once you appeal it, it might take about 5 years or 6 years, till then you don't get anything. Fortunately, if you won the case, what you get is only what you have deposited, not even the interest out of it. And when you are sure that you are bound to prove negligence, you cannot escape from that. There is a mediation cell in all the forums, district, state and national. Get this settled out of court. You just move an application to the president of the forum that I want to get settled out of court. Probably there is a mediation cell, wherein I am a mediation cell member of the district court. We can mediate and close the issue. Once the mediation is done, none can go to the appeal. This is the binding of the both the parties. So if it is beyond doubt, you just compromise yourself. New BNS Act, yes, 2024. Whoever causes death of any person, not amounting to whoever causes death of any person, not a culpable homicide, imprisonment of 5 years with a fine. If the same criminal negligence is done by the registered medical practitioner, the liability is 2 years of imprisonment plus fine. This applies only to the allopathic doctors. It doesn't apply to the dentist, doesn't apply to physiotherapy or Ayurvedic homeopathic. The registered medical practice in the respective state or in the NMC is applied only for 2 years and the fine. Earlier the fine was not there. Doctors used to get away by paying the fine, not the imprisonment. Now the imprisonment is a compulsion, fine is also compulsion. So how could medical indemnity insurance can save you? Yes, never ever go to the OT unless you have medical indemnity. However trivial it is, however simple it is. The next question arises, how much should be the medical indemnity? For practicing anesthesiologist, I would say that not less than 1 crore. Because I have come across anesthetists being slapped more than 1 crore under recent past 2023, 24, 25. So Which is the best insurance? Many times they ask me. None of them is the best. None of them is the worst. You have to see the policy conditions, inclusion criteria, exclusion criteria, then indemnify yourself. So there are very tricky things which the insurance people will not tell you. Any one accident in any 1 year. 1:1, 1:2, 1:3, 1:4. This is available in Indian indemnity policies. What do you mean by 1:1? Imagine that there is a 1 crore compensation awarded to you, and indemnity is 1 crore. 1:1 means 1 accident in a year. So that 1 crore is taken care by the insurance company. But if it is the ratio of 1:2, even if they award 75 lakhs, they award only 50% of the indemnified amount, 25% you have to sell from your pocket. If it is a 1:4 ratio, the liability per year is 25 lakhs. If they award 75 lakhs, you have to sell 50 lakhs from your pocket. The insurance company will take only the 25%. So in this case, I urge everyone to go for the 1:1 or 1:2, so that you are safe with 1 crore medical indemnity. 10 things the anesthetist should never do. Never ignore pre-operative assessment, which I've already told it. Never administer anesthesia without the functional monitoring. And never overlook the importance of airway examination. Never turn your back on the patient under the anesthesia. Never assume equipment is working without checking it. Never ignore the patient's positioning risk. Never administer a drug without knowing its effect. Never ignore an alarm in the monitoring system. And never forget to communicate with the surgical nursing home when the crucial time arises. However, the surgeon says that I'll finish in 5 minutes. Never ever do it. Never ever do it. Alarm, alert, document. Whatever you document, communicate. Whatever you communicate, document. This is what can be saved by the anesthesiologist in profession. So I think I've done within the stipulated time. If I have any questions, I'll be happy to take care.
Thank you very much, sir, for elucidating most of what we should know about the medico-legal implications of practicing anesthesia in this day and age. This was also supposed to be an interactive session. I now invite Dr. Vasant Kumar and Dr. Shivakumar onto the stage for the question and answer session. Audience may please put forward their queries.
I had one medication error, I'll tell you. I was supposed to attend a hysterectomy. Pre-op anesthesia was done. I had already done PAE. And I was a bit late. I told the patient, put the patient in the position where that I can come and give the spinal. And before I could give spinal, I could notice the patient was perspirating. Okay, there's a lot of sweating. Then I said, why are you sweating? The patient said, no, sir, I sweat a lot whenever I enter the OT, something like that. Even gynecologist said, I finished in 20-25 minutes to give a spinal. Somehow I was a bit reluctant. BP was double, but she was sweating. After 5 minutes, I recorded the BP was going down. We did the ECG, cardiologist, everything was normal. But within 15-20 minutes, the patient went to do the systolic 60. Then we refer the patient to the higher center, wherein with the triple inotrope, she came out of the shock. Ultimately, what I came to, because I had kept my anesthesia kit in that OT. Second day, I came and watched there. I asked the sister, what was the index was given? She said that antibiotic ceftriaxone was given, sir, and we took the patient. I came to know that it's only ceftriaxone anaphylaxis where the patient was in shock. If I had given a spinal, probably I would not have revived the patient. I would have accepted. I would have accepted that morally, ethically, legally, this patient has gone into the spinal shock where I could not have revived it. So be careful. And many times recently I've come across a patient wherein tranexamic acid was given instead of anamine, where the patient landed up in a problem, we lost the patient. The medication errors. Even if you discard the temple which was pre-loaded, make sure that you give the right dose and right drug to the right patient. And tranexamic acid, especially with the subarachnoid space, one of the best centers is mortality is 50 to 60%. Make sure that you will never ever do that mistakes. Yeah, please.
Sir, actually it was a wonderful presentation. Lot of information we got it actually. That's how actually we can maintain our work-life balance also, stress-free life. If you're too much under the pressure of surgeon, if you start shifting the patient, giving anesthesia, the anesthesia required by the surgeon, sometimes some people say, no, surgeon is not preferring, surgeon wants this one, that one, nothing doing. One more Supreme Court order is there. Surgeon doesn't have any say in the selection of anesthesia. It is between the anesthesiologist and the patient and whatever requirement, actually.
So I'm Dr. Suma from Mangaluru itself. I just wanted to know how, whether we should be providing the patient party, because the patient has passed away. Patient party wants the details of management of the patient. Are we entitled to give it on as a soft copy?
Yeah. Patient has the every right to ask for the hospital
Yes.
documentation. Okay? And as per the MCI, Code of Ethics now 2012, within 72 hours you are required to give it. Okay? And make sure that you acknowledge yourself that you have given to the patient.
Yes.
Okay, you can charge even hospital protocols, you can charge a reasonable fees also. Yes, you are duty bound to give the case papers to the patient. You can.
To the patient, yes, sir. This is not the patient. Patient has passed away.
Yeah.
They come after a month or 2
Yeah.
months to go
Legal
into
hires, we
details.
call it. Legal
Yes,
hires.
legal hires.
Yes, you are bound to give them.
Yes.
Okay.
But am I bound to give it over email, or are they supposed to come and collect it?
They have to come and collect. They have to come and collect. Because the limitation period for the consumer case is 2 years.
Yes.
Anytime they can come and ask it. Even if it's a more than 2 hours, if the discretion of the judges, he can condone the delay, we call it. Even if they come after 2 years, they can give it. You have to give it.
Okay, sir. The thing is, when we had given it with goodwill, soft copy was misused, and they had applied for insurance. An insurance company came up to us asking that this was already paid, why it has come. So that's how we got, and we stopped giving soft copies. We now attest it and give it hard copies, but patient party insists on sending it by email. It's 300 kilometers away. So I took a decision saying that we'll send you the hard copy,
Yeah.
register post, attested from our medical records.
That will be nice.
Yes.
That will be nice. Never ever entered an insurance company, including the lawyers. They
Yes.
came in the name of the patient's party, but never ever issued to the even advocate also, unless it's from the police or from the court.
Yes, thank you, sir.
So I'm Dr. Ritesh from Father Muller's Hospital here. We have been recently introduced in our hospital the electronic system where consent is taken, everything is electronically, and thumb impression of the doctors and patients is being collected. No signature, nothing. So is it valid in court? This is the question.
Yeah, that's a very tricky question. Somebody asked me on that. We ask the thumb impression of the patient if the patient is illiterate in the eyes of the law. Always, a copy paste the signature, that's valid. But only thumb impression of the patient doctor is not valid, sir. You have taken a signature, copy paste it, is authenticated. But only thumb impression, again, it gives a lot of queries.
Even doctor's signature, sir, it is everything is thumb.
No, sir, it's not accepted. It is not accepted even nowadays. Yeah, I had one patient wherein I faced it actually in the court of law. A patient interpretively died. The consent was not taken. So what did the doctors and others they did it? They took the thumb impression of the dead patient. They said in the court of law, yes, patient had given the thumb impression. The judiciary asked only one question, the opponent lawyer. What was the qualification of the patient? MA, English major. They took all the records. They never ever had any thumb impression. She had already beautifully signed in all the documents. Yes, came to know that it was fabricated by the anesthesiologist or the hospital and they slapped the compensation. No, sir. Yeah. Well done.
Yeah, so that brings us to the end of long but very valuable sessions. I would like to invite Dr. Sripad and Dr. Somalata to please present mementos and recognition to our speakers.
We will now request Dr. Sripat sir and Dr. Suma ma'am to hand over the memento to Dr. Sumesh Rao.